episode of Courts This Week presented by Live Law. I'm your host, Ostika Das, and I'll take you through the most significant courtroom developments from last week. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website, www.livelaw.in. In this episode, we are going to talk about the transfer of sexual violence cases in Manipur being investigated by the CBI to Assam and other developments relating to the Manipur ethnic clashes, SEBI's status report on the Adani Hindenburg probe, the PM Modi Degree Rao, Article 370 hearings, and much more. So let's dive into the headline. Let's begin with two important developments about Manipur, which has been witnessing ethnic clashes since May. As you know, after expressing concerns over the pace of investigation, the Supreme Court has started proactively monitoring the situation on ground. Earlier this month, it directed the CBI to handle 11 FIRs relating to cases of sexual violence with the assistance of 5 senior officers, at least one being a woman, drawn from the states of Rajasthan, MP, Jharkhand, Orissa, and Delhi. With respect to the cases being investigated by the state police, the Supreme Court has formed 42 SITs with one police inspector from other states. Notably, the court also formed a special committee comprising former Chief Justice of Jammu and Kashmir High Court, Geeta Mittal, former Judge of Bombay High Court, Shalini Joshi, and former Judge of Delhi High Court, Asha Menon, and entrusted it to look into the aspects of relief, remedial and rehabilitation measures, and restoration of homes and places of worship. 3 reports were submitted by this committee earlier this week. The first report highlights the loss of documents like Aadhaar cards, etc., of Manipur citizens in the riots and calls for assistance in procuring such documents again. The second report calls for the Manipur Victim Compensation Scheme to be improved and updated, bearing in mind the NALSA scheme. The third report proposes the appointment of domain experts for administrative direction. This week, the Supreme Court has also accepted the suggestion of the Centre to transfer the sexual violence cases being investigated by the CBI, now 27 in number, outside the state of Manipur to Assam. The central government had suggested the transfer of the trial to a judge in Assam designated by the Chief Justice of the Guwahati High Court, saying that judges in Manipur might belong to one tribe or community or the other. Expressing concerns over security, Solicitor General Tushar Mehta also urged the court to allow the accused to be produced in front of the designated judge in Assam virtually and kept in judicial custody in Manipur itself. The suggestion to transfer the trial was opposed by the lawyers appearing for the victims or the tribal groups, who initially argued that the survivors should be allowed to provide their testimonies in their own areas. The council also suggested states other than Assam for the transfer, like Meghalaya and Mizoram. But the bench was not persuaded and noted the limitations of these states in terms of infrastructure. However, to allay their concerns, the Supreme Court directed the acting Chief Justice of the Manipur High Court to designate one or more local magistrates before whom statements of survivors or witnesses may be recorded, both virtually and in person. Not only this, suitable arrangements could also be made so that people who have been displaced out of Manipur owing to the violence can also record their statements where they currently reside. To read more about the directions issued, you can visit our website www.livelaw.in. Next, let's turn to a development in the Adani Hindenburg controversy. The Securities and Exchange Board of India has finally submitted its status report to the Supreme Court, revealing that 22 out of the 24 probes have been completed, while 2 are ongoing. The Security Board's inquiry into the alleged non-compliance with minimum public shareholding requirements is still underway. This probe covered 13 overseas entities, including 12 FPI and 1 foreign entity classified as public shareholders of the Adani Group, many of which are located in tax haven jurisdictions. SEBI has said that establishing the economic interest shareholders of the 12 FPIs remain a challenge, but efforts are being made to collect economic interest shareholder details from 5 foreign jurisdictions to update its interim report. Also incomplete is the market regulator's probe into any unusual trading activity by entities in the Adani Group before or after the release of the report, and information from external agencies is actively pursued and awaited in this regard as well. Earlier this month, the Gujarat High Court refused to grant any interim relief to Delhi Chief Minister Arvind Kejriwal and Aam Aadmi Party's Rajya Sabha MP Sanjay Singh in their plea seeking a stay on criminal defamation complaint proceedings. For those who are unaware, these proceedings have been initiated after the Gujarat University filed a complaint accusing Kejriwal and Singh of making sarcastic and defamatory statements targeting the university regarding Prime Minister Narendra Modi's degree. The Ahmedabad magistrate trying this case has summoned Kejriwal and Singh to be physically present in court. This week, a Supreme Court bench headed by Justice Sanjeev Khanna refused to stay the trial in the criminal defamation case filed by the Gujarat University against the Delhi Chief Minister in view of the litigation pending before the High Court. The Supreme Court has temporarily halted a trial court's order that required Samajwadi Party leader Azam Khan to submit a voice sample for comparison with the CD-recorded hate speech he allegedly delivered in 2007. This relief came in response to Khan's plea against providing the voice sample after the Allahabad High Court declined to intervene with the trial court's direction. For more context, this case originates from a complaint accusing Khan of making derogatory remarks in 2007 against former Chief Minister and Bahujan Samaj Party Supremo Mayawati and a specific community. Khan is accused of violating various sections of the Indian Penal Code, the Representation of the People Act, and the SC/ST Prevention of Atrocities Act. The Supreme Court has once again reiterated its unwillingness to take up individual cases of hate speech owing to the logistical difficulties. At the same time, it has stressed the need for peace, harmony, and brotherhood between different communities. In view of this objective, it earlier suggested the formation of committees by district police chiefs that would assess hate speech complaints and issue appropriate directions to the concerned police officer, as well as periodically review the progress in all ongoing cases. This week, when the pleas seeking action against hate speech were taken up, the court proposed a number of other suggestions. It said that increasing the area under CCTV surveillance would act as a deterrent. Apart from this, the court suggested the deployment of plainclothes police officers in areas or at events where provocative speeches are likely to be made, and for nodal officers to maintain a record of all videos of hate speeches emerging from violence-hit areas. Once again, the Justice Sanjeev Khanna-led bench stressed on police sensitization, besides pointing out that measures to counteract both fake and doctored videos and hateful content would have to be actively taken. After hearing the court's suggestions, the centre has promised to prepare draft guidelines to tackle hate speech. Other stakeholders, including state governments, have been permitted to submit their suggestions. Notably, the Supreme Court has also sought responses from state governments with respect to the status of their compliance with the Tehseen Poonawalla ruling requiring the establishment of district-level notification. Let's now turn our attention to the caste survey conducted by the Bihar government, which received the green light from the Patna High Court last month. The key highlight from the most recent Supreme Court hearing is that the central government sought and was granted permission to submit its view on the survey. Solicitor General Tushar Mehta told the bench headed by Justice Khanna that this exercise may have some ramifications, but quickly clarified that the centre was not for one side or the other. Another thing to note is that there will be no stay or temporary stop to the publication of the survey findings. The Supreme Court reiterated this stance against issuing any such order without first hearing all parties involved and unless a prima facie case for stay is established. During this week's hearing on the remission granted to Bilkis Banu's rapists, the Supreme Court questioned whether a convict should be granted the license to practice law, emphasizing the profession's nobility. This remark was made by Justice Ujjal Bhuiya after senior advocate Rishi Malhotra, appearing for convict Radhesham Shah, highlighted his client's rehabilitation efforts in jail and his post-conviction legal practice. Notably, the court also rejected the argument of judicial propriety, stating that its 2022 judgment holding Gujarat government as the competent government to deal with the convict's application for premature release would not bar a judicial review of the remission orders. The judges clarified that the two causes of action were distinct. One was by a convict for a mandamus for consideration of his remission application, while the current pleas are against the remission orders themselves. Other than this, Advocate Sonia Mathur appeared for another convict, Vipin Joshi, and argued that the remission was earned and was not a matter of charity, and if any flaws were found in the process, it was for the state to answer and not for the convict's rights to be undone. On behalf of the Union of India, ASG SV Raju mentioned the absence of a negative opinion from the CBI. After hearing their submissions, the hearing was adjourned until August 31. Don't forget to visit our website www.livelaw.in to read our detailed report. Next, let's talk about the Article 370 hearing. This week, the petitioners repeated that the abrogation of Article 370, which affects a historically religious minority, is a regressive step and that the constitutional promise made to the people of Jammu and Kashmir must be upheld. Notably, the Supreme Court observed that the argument that the application of the Indian Constitution to Jammu and Kashmir would remain frozen after the dissolution of its Constituent Assembly in 1957 could not be accepted. On other states enjoying similar status, the Union government told the court that it had absolutely no intention to interfere with the special provisions applicable to either northeastern states or any other part of India. On the 10th day of the hearing, the respondents began their arguments, with Attorney General R. Venkataramani leading the charge. He began by quoting Lincoln, where he said that a limb can be amputated to save a life, but a life is never given to save a limb. To this, the Chief Justice said that a situation could not be postulated where the ends justified the means. Means should also be consistent with the ends. The Attorney General further said that the combined reading of the Instrument of Accession and the proclamation, followed by the adoption of 370, shows that any and all traces of sovereignty were surrendered. Solicitor General Tushar Mehta then argued that the abrogation of Article 370 was required to ensure that the people of Jammu and Kashmir can avail welfare schemes of the centre and enjoy similar rights and privileges as the rest of the country. The Constitution Bench will continue to hear the matter on Monday, so stay tuned. This week, the Centre informed the Supreme Court about its application to withdraw the oral undertaking given in November last year, pledging to maintain status quo with respect to the release of the genetically modified or GM mustard. If allowed, this would be the first time a transgenic food crop is commercially cultivated in India. Because of the retirement of Justice Dinesh Maheshwari, despite a major portion of the arguments having been concluded, the matter had to be placed before another bench to be heard afresh. The centre has now sought discharge from its earlier commitment, stating that it was specific to the matter's imminent final hearing and was not meant to halt research or testing under the conditional approval it had secured in October last year. Emphasizing mustard's significance as a major edible oil and seed meal crop meeting India's demand, the government has sought permission to proceed with the environmental release of GM mustard, especially considering the upcoming September and October sowing season. The Supreme Court had earlier directed a 10-day status quo to be maintained with respect to the demolition drive conducted by railway authorities in a settlement near railway tracks in the backyard of the Krishna Janmabhoomi in Mathura. Railway authorities have defended the demolition, citing plans to convert a rail stretch from narrow to broad gauge to facilitate the operation of trains like Vande Bharat. Residents, however, have cried foul and alleged unfair eviction from the predominantly Muslim settlement. This week, a bench of Justices Aniruddha Bose and Bela M. Trivedi declined to extend the status quo order after the railway stated that the demolition was complete. The petitioner's standing was also questioned since he wasn't a resident of the area under demolition. This matter will be taken up again on Monday. Former police officer and alleged encounter specialist Pradeep Sharma, accused in the Antalya bomb scare and Mansukh Hiran murder cases, has been granted bail by the Supreme Court. A bench comprising Justices A.S. Bopanna and P.S. Narasimha delivered this verdict after hearing Sharma's plea challenging the Bombay High Court's denial of bail in January. Sharma was arrested along with others for his alleged involvement in destroying evidence, conspiracy and executing Hiran's murder. Despite co-accused Riazuddin Qazi being granted bail, Sharma's plea was rejected by the High Court. Earlier, Sharma had received interim bail for 3 weeks to visit his ailing wife, which was later extended by another 3. The Supreme Court declined to revoke the bail of Jitendra Narain, former Chief Secretary of Andaman and Nicobar, who is accused along with other officials of gang raping a 21-year-old woman. The decision followed a batch of pleas seeking the cancellation of his bail, including one from the survivor who had filed an FIR against him. Narain, a suspended IAS officer, was granted bail in February by the Port Blair bench of Calcutta High Court. The survivor has alleged that she was lured into his home with the promise of a job, where she was raped by top officials. The Supreme Court has deferred the hearing of the CBI's appeal against bail granted to Lalu Prasad Yadav, the former Chief Minister of Bihar and Rashtriya Janata Dal chief, in a fodder scam case to October 17th. Yadav, convicted in multiple cases related to fraudulent withdrawals from the state treasury between 1992 and 1995, was granted bail by the Jharkhand High Court on the grounds of having served half of his prison term. This week, the CBI argued that Yadav's sentences should run consecutively and not concurrently. ASG S.V. Raju, appearing for the central agency, also sought for the appeals to be heard in September. However, the court declined the CBI's request for an earlier date, stating that it had already listed a number of cases in the month of September. The Supreme Court has once again extended Satyendra Jain's interim bail. The Aam Aadmi Party leader and former Delhi government cabinet minister has been accused in a money laundering case and was arrested by the Enforcement Directorate last year. He was granted interim bail earlier this year due to medical reasons. Senior advocate Dr. A.M. Singhvi, representing Jain, stated that he is currently in rehabilitation following a difficult spinal operation. Despite opposition from Additional Solicitor General S.V. Raju, who advocated for an independent examination by AIIMS doctors, the bench headed by Justice A.S. Bopanna agreed to extend his interim bail till September 1st. The main bail application will also be heard on 1st of September. Next, we have a development in the Kaveri River dispute. This dispute is a long-standing one between the states of Karnataka and Tamil Nadu. It began in 1974 when Karnataka, the upper riparian state, started diverting water without Tamil Nadu's consent. The tussle reached the Supreme Court after the Kaveri Water Dispute Tribunal in 2007 finalized the water sharing formula. Besides deciding on the sharing of water, the tribunal had recommended setting up a Kaveri Water Management Board and the Kaveri Water Regulation Committee. Certain modifications were made to the award by the Supreme Court in 2018. Last week, the Tamil Nadu government approached the Supreme Court urging it to compel Karnataka to release 24,000 cusecs of water from its reservoirs. The state government also prayed for a direction to its neighbouring state to guarantee the release of the designated 36.67 TMC of water for September 2023 in accordance with the tribunal's final decision from 2007. Senior advocate Shyam Diwan, appearing for Karnataka, cited rainfall shortage to predict inevitable cutbacks, while Mukul Rohatgi, appearing for Tamil Nadu, highlighted water release commitments and its timeline. Acknowledging its lack of expertise, the Supreme Court bench led by Justice B.R. Gavai directed the Kaveri Water Management Authority to submit a report on the matter by next Friday. The Supreme Court held a special sitting to hear a rape survivor's urgent plea for pregnancy termination after the Gujarat High Court refused her relief. She is an Adivasi woman from a remote village in Gujarat who was allegedly raped under the false pretext of marriage. During Saturday's hearing, the bench led by Justice B.V. Nagaratna directed a fresh medical examination to assess the woman's fitness to undergo the procedure of a medical termination of pregnancy. Interestingly, after this order was passed, the single judge of the Gujarat High Court that refused her relief passed an order by way of clarification. This was harshly criticized by the judges on the Supreme Court bench, who said that they did not appreciate the High Court's counterblast to their order. Besides this, the Supreme Court also allowed the rape survivor to immediately get an abortion after observing that forcing a woman to have a child conceived as a result of rape is against our constitutional philosophy. This week, the Supreme Court acquitted a death row prisoner convicted in the murder of his two brothers and son and ordered his immediate release. The victims, who were allegedly set on fire by him, eventually succumbed to their injuries, but the police managed to record two of their dying declarations, which then became the central hinge of the prosecution's case. On the basis of these dying declarations, the Sessions Court arrived at a guilty verdict, which was later upheld by the Allahabad High Court in 2018 after finding no discrepancies in the statements. Despite the concurrent findings of the lower court, the Supreme Court was not persuaded that a conviction could be sustained based on these dying declarations alone, noting the absence of corroborative evidence and the discrepancies with eyewitness accounts. While overturning the death row prisoner's conviction, the court also listed out some factors that would help determine the weight of a dying declaration, although not its admissibility. Let's turn to some news from High Courts. Remember that Canada-based Tamil student who was arrested in 2018 for allegedly raising slogans against Bharatiya Janata Party on a Chennai-Thoothukudi flight, in which then Tamil Nadu BJP President Tamilisai Soundarajan was a co-passenger? The Madras High Court has quashed the FIR against Lois Sophia for her fascist BJP down slogan after noting that it did not constitute an offence and was trivial in nature. The court found no grounds for charges of public nuisance under Section 290 of the IPC or for the criminal action to be warranted. Interestingly, the court also observed that the police had failed to observe the procedure prescribed under the Code of Criminal Procedure. Congress leader Rahul Gandhi has approached the Bombay High Court contesting a magistrate court's decision to exhibit transcripts of his alleged defamatory speech as evidence in a case filed by a Rashtriya Swayamsevak Sangh functionary. The RSS worker accused Gandhi of defaming the RSS by linking it to Mahatma Gandhi's assassination. Gandhi argued that the High Court had earlier dismissed the request to admit the transcript as evidence, stating that compelling an accused to admit or deny a document violated constitutional mandates. Despite this, the magistrate allowed the transcript and annexures to be presented as evidence. In the High Court, Gandhi has contended that obtaining certified copies of his 2014 plea did not grant the right to compel admission or denial of the annexures. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire Live.in team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audio-visual format, we need your support. So don't forget to do the Fantastic Six. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications, and lastly, swing by our website at www.live.in for our in-depth reports. I'm your host Ostika Das, and I will see you again next time.